Today we're talking about bond conditions. Can a judge require you to test at a drug testing facility before you've been convicted of a crime during the period of time where the case is still pending? Well, they can, and that's what's called bond conditions or ancillary conditions of bond. We do cases in Houston, Galveston, Montgomery County, Walker County, Brazos County, and most of the other surrounding counties here in the general Houston area. And in all those cases, if you have a felony offense, you've been arrested for, let's say, possession of a controlled substance, penalty group 2 because of a vape pen or something like that, or a different felony, maybe it doesn't even involve drugs. For example, evading arrest in a motor vehicle, you could be arrested for that. And if it's a felony or Class A misdemeanor, you're likely to be put on what's called conditions of bond. In Harris County, they would call it pretrial services. In Montgomery County, they call it ancillary conditions of bond. And this is basically like putting you on probation before the case is over. When this happens, you have to report to the probation department or adult community supervision, they might call it. You have to call a phone number every day to see if it's your turn to get drug tested. A lot of different things like this. The biggest question we get about this is what they're doing to me legal? Can they punish you? Can they have you basically on probation before you've been convicted? Now, this was fought, sort of back in the day, I suppose, and the courts in Texas have determined that a judge may impose reasonable conditions on pretrial release. So when you get arrested, you're taken to the jail, right? Or when a warrant goes out for your arrest because they think you committed a crime on some other day, that warrant goes out, again, you're taken to the jail. That's the beginning of a criminal case, is you're taken to the jail. And then to get out, you have to make what's called a bond. That's where you pay a bail bondsman or something like that. Maybe you paid a cash bond and you just brought a cashier's check up to the jail with the exact amount of your bond and paid that. Well, if you've done that, then they're going to release you, but the judge still has to approve the amount of that bond and if, when you're released from that bond, whether you have these conditions. So one of the conditions that they can have it written out in the code is drug testing. Another one would be for you to just check in. They could have put an ankle monitor tracking your position. It's anything that the court thinks is required for you to abstain from violations of the law while you're out on bond, and then also to assure your appearance in court for your court date. There's some factors that we can argue anytime someone is challenging either the amount of the bond or a condition of the bond. And so this happens a lot in a family violence case context. In a family violence case, the judge is going to put a no contact order in place. They're also going to put conditions where you can't go back to your own home if you were living with the victim in the family violence case. And it may not be the case that the victim even wants to continue to prosecute, and the court still has jurisdiction to kick you out and to allow them to stay in your home, even if they're not on the lease. Let's say it's just a boyfriend-girlfriend situation and the girlfriend is arrested for assaulting her boyfriend. It's her apartment. He was just staying there. Well, he's going to get to stay there unless you can have an effective argument from your attorney to get those bond conditions amended. If, let's say, you test positive for marijuana on your first visit to the bond supervision department, typically they are not going to revoke your bond for a positive test within 30 days of the day of the arrest. But if it's been more than 30 days and they think that the alcohol or drug or marijuana or something should be out of your system by then, and then you test positive for marijuana, 60 days later into a bond while your attorney's still gathering evidence in the case, then that could be a situation where you do end up with a bond violation. And a bond violation means you go back to jail. You may have a new bond set. It'd be the same as if you missed court entirely. And obviously that's very frustrating for somebody who's been arrested already. So one of the things that we have at my law firm is a probation specialist. We've got two, actually. Both are former probation officers working for 34 and 15 years, respectively, at the probation department, so that we have somebody who knows from the inside out how to handle these issues when they come up. And we have a very good success rate with our clients being in compliance with all those bond conditions, because you don't want something to sneak up on you, land you back in jail while we're in the process of trying to get a case handled, or even dismissed, and then you having to do additional jail time when you weren't thinking you were going to at all. Thanks for tuning in. As always, we'll see you guys next time. This is all for educational purposes. And if you have any questions, leave a comment below and we'll try to get to those in a future video. Thank you.